Welcome to the deep dive. If you follow tort reform, you've probably heard the quick take on damage caps in Florida medical malpractice cases.
Yeah, the soundbite usually goes something like, the Florida Supreme Court just declared them unconstitutional, full stop, in McCall and Kalitan. End of story.
Right, like it was just a simple clean sweep.
And honestly, that summary, it misses so much of the constitutional depth, the real dialogue happening in those cases. It wasn't really a permanent ban.
That's exactly why we're diving in today. People often treat McCall and Kalitan as just, the legislature losing a battle.
But when you look closer, these decisions are really about fairness, about proportionality, and crucially, about where the limits of legislative power actually lie. It's a constitutional line-drawing exercise.
We've touched on this tension before, haven't we? Thinking back to cases like Kluger v. White.
Exactly. That fundamental balance between your right to go to court and seek redress and the state's power to step in and regulate things, especially when there's a genuine public crisis.
So our mission today is to get clear on what the courts actually held in McCall and Kalitan, why they used equal protection specifically.
And just as importantly, what they didn't hold. This isn't just about formulas. It's about how we define justice in these really difficult situations.
Okay, let's start with the first big one. A State of McCall v. United States back in 2014. This case was all about wrongful death claims.
That's right.
So what specific part of the law was under the microscope here?
It was section 766.118, subsection 2, specifically the aggregate cap mechanism for non-economic damages.
Aggregate cap meaning one total limit.
Exactly. A fixed total amount, let's say $1 million, just for example, for all non-economic damages tied to a single incident of malpractice resulting in death. Didn't matter how many survivors were left behind.
You can immediately see how that might lead to some, unequal outcomes, which sounds like an equal protection issue waiting to happen.
It absolutely was.
Yeah.
The court used a really powerful comparison to show the problem. Scenario 1. Negligence causes a death. Victim leaves just one survivor, maybe a spouse, maybe a child.
Okay.
That single survivor, facing their own immense grief and loss, could potentially recover damages up to that full $1 million cap.
Makes sense so far, but then there's scenario 2.
Right. Same medical negligence, same death. But this time, the victim leaves behind, say, 5 survivors, a spouse, 3 kids, maybe an elderly parent, a much larger group suffering loss.
And they all had to share.
The exact same $1 million cap. The total pot didn't change, even though the scope of the human tragedy was demonstrably larger.
Wow. Okay, that really highlights the issue. The family hit harder with more people grieving, ends up getting proportionally less just because of family size.
Precisely. The court called it arbitrary and irrational. It discriminated between groups of survivors based on something totally unrelated to the negligence itself, how many people happened to be in the immediate family.
So the structure itself was flawed. But what about the justification? The legislature must have had a reason for putting the cap in place.
Oh, absolutely. The stated reason was always the supposed medical malpractice crisis back in 2003. The idea was that high insurance costs and lawsuits were driving doctors away, hurting healthcare access.
The classic justification for tort reform measures.
Yes. But the key thing is, by 2014, when McCall was decided, the court looked at the actual facts on the ground, the data.
Yeah.
And the crisis narrative just didn't hold water anymore. The court literally said the justification was dubious and questionable at best.
Why dubious? What did the data show?
It showed the physician numbers in Florida were stable, even increasing in some areas. The predicted exodus of doctors hadn't happened. So the factual basis for the cap, the whole reason for infringing on recovery rights, had basically evaporated.
So even under rational basis review, which is usually pretty deferential to the legislature.
Even then, it failed. Because the aggregate cap with its discriminatory effect wasn't rationally related to a currently existing legitimate state problem. The crisis rationale was obsolete.
Got it. But it's crucial to remember the scope here. What did McCall not decide?
Super important point. McCall was very specific. It struck down only the aggregate caps and only as applied to wrongful death cases.
So it didn't touch caps in personal injury cases, or caps that applied per person, per claimant.
No, it explicitly left those questions open, which of course set the stage perfectly for the next major case just a few years later.
Right, which brings us straight to North Broward Hospital District v. Kalitan in 2017. If McCall was about the collective loss of a family,
Kalitan was about the individual catastrophic harm suffered by the patient herself.
tell us about Susan Kalitan's situation.
It was devastating. She went in for a relatively common procedure, carpal tunnel surgery, I believe. But due to negligence, she suffered a perforated esophagus, ended up in a coma, facing lifelong, really severe injuries.
Just horrific. And the jury recognized the severity of that harm.
They did. They awarded significant non-economic damages, something like $4 million, reflecting that catastrophic impact. But then the statutory cap kicked in.
And this time it wasn't an aggregate cap, right? It was a different type.
Correct. This time it was the proclaimant cap being challenged, a limit on how much any one individual could receive for non-economic damages, even if their actual damages awarded by the jury were much higher.
So how did the court take the reasoning from McCall, the equal protection argument, and apply it here? The issue wasn't family size anymore.
The arbitrary distinction just shifted. Instead of discriminating based on family size, the court found the proclaimant caps discriminated based on the severity of the victim's injury.
How so? Explain that discrimination.
Well, think about it. If you suffer a relatively minor injury from malpractice, maybe your non-economic damages are assessed by the jury at, say, $100,000. If the cap is $500,000, you get your full $100,000. No reduction.
Okay. Makes sense. You're fully compensated because you're under the limit.
But now take someone like Susan Kalitan. Catastrophic injuries. The jury says her pain, suffering, loss of enjoyment of life is worth $4 million. But the cap forces that down to maybe $500,000 or $1 million, depending on the specifics.
Ah, I see. So the person who suffers the most severe harm is actually the one who gets the least proportional compensation simply because their damages exceeded an arbitrary legislative number.
Exactly. The law ends up disproportionately impacting those with the most devastating injuries. They bear the entire burden of the cap, while those with lesser injuries might feel no impact at all. It creates two tiers of victims based purely on the dollar amount of their suffering.
There was a really striking analogy used in the source materials to illustrate this point, wasn't there, about scars?
Yes, a very powerful one. It went something like, a scar on the hand of a truck mechanic means very little when compared to a scar on the face of a promising 18-year-old fashion model.
That really drives it home. Justice isn't a simple formula, it's deeply contextual. The impact of an injury depends entirely on the individual's life circumstances.
Precisely. And a flat cap completely ignores that reality. It substitutes arithmetic for individualized justice.
And just like in McCall, the underlying justification in the 2003 crisis was again found lacking.
Even more so by 2017. The court essentially reaffirmed the McCall finding. The empirical evidence just didn't support the idea of an ongoing crisis that would justify these caps anymore. Without that valid public necessity, the caps were simply an unconstitutional burden on the most severely injured.
Okay, so let's pull this together. We need to correct that common, oversimplified soundbite. What's the real takeaway from McCall and Kalitan combined?
The crucial point is that these cases struck down the specific 2003 version of the damage caps. They didn't issue a blanket ban on all possible caps forever.
Why did that specific 2003 law fail?
Two key reasons, echoed in both cases. First, the factual justification of the 2003 crisis was found to be obsolete. It didn't match the reality in 2014 or 2017.
The necessity was gone.
Right. And second, the mechanisms of the caps created irrational distinctions. In McCall, it was discriminating based on family size. In Kalitan, it was discriminating based on the severity of the injury. Both failed the rational basis test for equal protection.
So the door isn't completely shut on the legislature. They could theoretically try again.
Absolutely. The rulings essentially put the ball back in the legislature's court, but with a much higher bar. They need to demonstrate a current, factually supported public necessity.
And design a cap that's actually rationally related to that current problem without creating these kinds of arbitrary discriminations.
Exactly. They have to prove the need now, based on today's conditions, not rely on old fears or outdated data from nearly 2 decades ago. The burden of proof is squarely on them.
It's fascinating how these cases also kept coming back to the role of the jury. It feels like more than just an equal protection argument.
It definitely is. There's a strong undercurrent protecting the right to trial by jury, which is Article 1, Section 22 of the Florida Constitution. The idea is that the jury is the conscience of the community.
And their job is to hear the specific facts, see the plaintiff, understand the context.
And then decide on fair compensation, especially for something as intangible as pain and suffering. A rigid cap basically overrides that judgment. It says, sorry, jury, we don't care what you found based on the evidence. The legislature already picked a number.
It replaces that community judgment with, as you said, legislative arithmetic, an intrusion on the jury's constitutional function.
It is. And this ties into that bigger picture, that sort of locking social contract idea we discussed. The state can ask citizens to limit their rights, like the right to full recovery, only when there's a compelling, proven public need, like the Kluger test requires.
It's a conditional surrender of rights.
Exactly. It's like the state saying, okay, we need you to take one for the team here because we have this genuine crisis. But if that crisis turns out to be exaggerated, or if it just goes away over time,
Then the deal is off.
then the justification for limiting the right disappears. The caps become, as the court might see it, an unjust imposition. The state can't keep restricting your rights based on a necessity that no longer exists.
So it's all about constitutional proportionality. The legislative intrusion has to match the scale and reality of the problem.
Precisely. Proven crisis. Okay, maybe limited legislative controls are permissible, crisis disproven or gone. Then the scales tip back towards the full constitutional right, including the jury's power to determine damages.
It really forces the legislature to stay connected to empirical reality, doesn't it? You can't just pass a law based on a crisis narrative and then walk away for 20 years.
That's the core message. The law has to track the facts on the ground. Policy can't operate in a vacuum sealed off from current data.
It's not just about the individuals, right? But about ensuring the whole system, legislature, courts, juries, functions with a degree of factual integrity.
Well put. It demands an ongoing dialogue between the law and the real world it governs.
So wrapping this up, the true lesson from McCall and Kalitan isn't damage caps are dead.
No, the real lesson is, if lawmakers want to invoke necessity to limit constitutional rights, they need to bring receipts. They have to prove it with current solid evidence. Legislative convenience or historical fears aren't enough when fundamental rights are at stake.
The courts essentially demanded that the justification for the law keeps pace with reality. The dialogue between liberty and necessity is ongoing.
It's a constant balancing act. And these decisions aim to recalibrate that balance, emphasizing that constitutional rights can't be sidelined by outdated justifications.
Which leaves us, and leaves you, the listener, with something to think about. If policy, especially policy that limits fundamental rights like access to courts and jury determinations, must track empirical reality to stay constitutional,
Then the big question becomes,
how often should the state have to revalidate its reasoning? How often does it need to prove that the crisis still exists, that the necessity for interfering with the jury's role and capping recovery for the most severely injured is still real right now? Thinking about that really defines where we draw the line between legitimate regulation and arbitrary government power.
a question with no easy answers, but one that gets to the heart of these cases.
Absolutely. We'll leave you with that thought. Thanks for joining us on The Deep Dive.